This is slightly different from what you've been hearing this morning, because this morning we were engaged in the fine detail of listening to evaluations of specific interventions. This is going to be a more broad brush, what I'm going to say. Secondly, we're just in the middle of it. It's very much work in progress. We've a lot of recent qualitative research has just come in the last month, which we haven't quite absorbed, so it's work in progress. As you see, it's a project that involves a number of partners to explore intensive and remand fostering. It's a 2-year project, as John said. BAAF is the applicant and lead partner, and it runs from last January till the end of this year in terms of the funding. And it's funded by the Daphne 3 Child Friendly Justice Initiative of the European Commission. Just say something about the origins of the project. BAAF's been a member of the Eurochild network for a few years, from 2009, and I think that symbolised an interest in exploring the possibility of working in partnership with other countries. We were struck by the promising green shoots findings of the initial intensive fostering pilot. I think that was also an influence on the choice of the project. Thirdly, I would say there's internal BAAF dialogue around brand name models in terms of intervention. A number of publications that BAAF publishes have been discussed this morning in terms of training models. A number of BAAF professionals have been trained in the details of the applicability of some of these models. Patty Chamberlain's name was mentioned this morning. I went to a 5-day course that she led on facilitating keep groups under the Oregon social learning model. So I've got a kind of sense of the strengths and weaknesses of particular kind of models, and also a sense of what meta-analysis is saying about how you should explore some of the strengths that different models can bring to bear, and in that way maybe avoid some of the restrictions and costs and limitations of being tied to a particular model. I must say though, having worked with that 5 days with Patty Chamberlain, something about the person and the model stayed in my mind. There's the model that Patty Chamberlain was teaching us about keep, and she was extraordinarily committed and extraordinarily resourceful about and creative about how she applied that in the training that I attended. But obviously she brought much more than that. She brought more than a model. She brought a kind of a passion and a credibility that exceeded what the model promises. And so I think there's an issue about keeping an eye on the larger picture. I also brought to this project my own professional experience of youth justice, sort of before and after the 1998 watershed, if you put it like that. And the final thing is I want to mention about a kind of moral driver, which I think had been particularly concerning me for some years, about the deaths of children in custody. And there's particular custody problems, as you know, in England. Custody is a dangerous place for young people. These are statistics from the Youth Justice Board that you're very familiar with, but it's inherently obvious that the European child-friendly justice guidelines, with their emphasis on minimal intervention and educative alternatives, kind of rings very loud bells when you look at the kind of national disgrace in England of the very large number of young people who've died over the last 20 to 30 years in custody in circumstances that still lack a detailed independent inquiry to look at the pattern of those. In terms of building from research, you've already had this morning a kind of a really expert account from Nina Bihal of both the intensive fostering pilot and the other research that she's been overseeing, I'll just say that in terms of the other placements, the other intensive fostering placements, it's not been easy to get hold of outcome data about how they're going. It's not been published, I gather. We've got some verbal information about around this from the Youth Justice Board indirectly, about 100 young people, and that there have been positive signs of improvement in literacy, ability to manage on their own, reduction in readmission to care, and promising signs in terms of a reduction in reoffending rates. But that's ultra soft data in this methodologically sophisticated company, but it's kind of it's not unpromising, and some seriously positive news about literacy gains as well that I'll come back to in a minute. So coming back to the deaths of children in custody, that's the list that John Drew here, the ex-chief exec of the Youth Justice Board, displayed in a presentation at the University of Bedfordshire that struck me very strongly. But the phenomenon had struck me some years before as something that one needed to think about. In terms of our partnership, it's a kind of broad group of countries from, we've got Bulgaria, we've got Hungary, we've got an academic partner in Italy, and we've got some associates in terms of service delivery, local authorities in Budapest and in Kensington and Chelsea in England. So it's quite a broad brush, and we've got two networking organisations, the International Juvenile Justice Observatory in Brussels and the Bulgarian National Network based in Sofia. It's rather complicated to manage, and I've not being very smart myself, I'm glad that I've got access to a lot of smart people, and that's been very supportive, both in BAAF and in the partnership. So our aim is, you can see the ambition, it's to specify a European-wide good practice model for responding for children in conflict with the law, responding by exploring the applicability of fostering. And the principles are from the Council of Europe's Child-Friendly Justice Guidelines on minimising detention and maximising integration and inclusion and combating marginalisation. And we've been strongly informed by consultation and research, but we've got a number of methodological hurdles still to climb and a dissemination process to deal with. We've had to widen the scope because, of course, the age of criminal responsibility in England is 10, and it's determinedly staying at 10 as far as the government's response to the UN inquiry is concerned that was published recently. But that doesn't make any sense in terms of the needs of our partner countries, where what we're looking at from 10 to 14 across our partner countries are kind of different sorts of punitive welfare systems in crisis, where although there's the formal age of criminal responsibility in many of our partner countries is 14 or 15, the reality is much more kind of difficult in terms of a landscape without the formal protections of the UK system, though with some opportunities for destigmatisation that our own system doesn't allow. So we've widened the scope to look not just at children in custody, but children at risk of being institutionalised by being sent by administrative or fiat or professional fiat without procedural safeguards into significantly low quality institutional care in our partner countries. And we've also, because of the age of criminal responsibility preventing findings of guilt, we looked at the concept of conflict with the law and antisocial behaviour as a kind of wider remit. We've, as is the well-worn path in these international projects, we commissioned desk analyses from the partner countries. We did an initial filtering survey just to see what was out there in terms of the provision of alternative family care within the youth justice system in Europe, because one of the original features of our project is obviously we're trying to bridge two domains of youth justice and children's social care in fostering. So we did an initial filtering survey. We've commissioned and just received 24 reports from the remaining EC countries, looking at a number of focused questions. We asked country experts, and we've just completed the qualitative research from the 4 partner countries that was done by focus groups. So where are we? We have got the 26 of the 27 country reports and the 4 national research reports done. To be done is the national policy guidelines. Plus, we've got to look at a protocol of intervention that is something that's going to be available for any country to draw on, that can pitch the professional aims of the project in a way that is replicable in terms of practice and is consonant with European law. We're also devising a training program for interdisciplinary and single discipline use, quality intervention standards, and country-specific information, perhaps, or broader brush information for young people. So with the 4 focus groups in each country, they've been completed. We looked at high-level or institutional actors. The second group was of foster carers and their professional support staff, either social workers or psychologists, depending on the country's system. Birth families, and fourthly, care or custody experienced young people themselves. So far, what we've learnt, huge problems in pursuing the goals of the project. There's particular challenges across the partner countries. Each partner country has very different ways of conceptualising and thinking about their problems. The obstacles to progress are very different in each country as well, be they policy or political, social, cultural, or in terms of resources, financial. There are different retributive and punitive pressures within the policy climates of each of the countries to combat. And also, it's clear from the focus groups that there's a strong expectation that the continuing role of children and birth families should be integrated into the kind of fostering vision, and that we should really centralise a relationship-based set of protocol proposals. Our partners have all been extremely receptive to the idea of expanding mainstream and innovative fostering practice and exploring alternative family care-based options within their youth justice system, though they're looking at a wider range of teenagers than the more narrow starting point in the UK. And in fact, it was rapidly brought to our kind of notice in the early weeks of the project, let alone the first 6 months, that this was not so much distorted, but very shaped by a kind of UK perspective on what the strengths and possibilities of foster care were, and that across the partner countries, foster care was seen partly as a child protection intervention at a much earlier stage of children's careers and development, and also as a harder-edged alternative to punitive measures at a later stage of an offending career. So there was a wish for a kind of broader-based programme and a broader-based kind of dissemination and advocacy picture to emerge from the project. The particular issues in England have concerned education. Educational exclusion has been a nightmare for youth offending teams, and with commonly receiving anecdotes of children out of school significantly for 2 or 3 years, a kind of a really difficult set of feedbacks on that. And there was considerable anxiety about involving young people and ensuring their voice is heard, connecting to the fact that our current systems for accessing the young person's voice tend to favour those who can cope with those systems. They're not kind of systems based on a kind of co-design of the participation mechanism based on the needs of the children you're actually trying to engage. They're looking at fitting a certain cadre of children into pre-designed adult-orientated feedback systems. So I think there's real problems about how we talk to and the mechanisms we use for talking to children. There's issues specifically about the complexity of the IF model, if it was going to be generalised, and about the difficulty of recruitment for the more challenging or dangerous young people. Just one slide each on each of the countries to give you a sense of the disparateness of the needs. I say disparate, I could easily have written it desperate for Bulgaria. It's the poorest European country, and its needs are extremely acute. The initial sort of dialogue with the Bulgarian NGOs was on a level of was kind of cautious and rather inhibited. As our partnership has sort of developed with them, they've become much more kind of ruthlessly honest, really, about the root and branch changes that their system, you know, really kind of badly needs in terms of whole system change, combating predominantly punitive attitudes, you know, across their services. Introducing a children's court would be an innovation, introduced in Germany in 1922, wasn't it? That would be an innovation in Bulgaria. Significant need for alternatives to closed institutions and for a national programme of multidisciplinary training. Procedural rights of children need protection under interrogation was a particular emphasis. Italy, a kind of different picture in that the main emphasis has been on introducing a culture of fostering, introducing in terms of public esteem and visibility, a higher profile for the development of fostering and the recruitment of foster carers and the training of professionals, particularly justice professionals, in the value of fostering. An emphasis on learning by doing, and a challenge to the traditional Italian idea of the family by looking at foster care as a cooperative ecosystem that can work alongside families and kinship networks. That is something that's our Italian partners say their government struggles with. Particularly the legal advisor to our project is a professor in Salento, where the whole region has been innovative in developing something that's akin to English special guardianship, which is called mild adoption in Apulia, where you escape the restrictions of the current law in Italy, which is that fostering is limited to 1 year to be renewed once, ultimately 2 years, which obviously makes no kind of developmental sense in many situations. So they're forced to resort to various kind of complicated legal get-arounds to cope with that. Mild adoption is a much more, you know, kind of radical alternative to that. It's no irrevocable break with the birth of parents. It's compatible with family links and contact, but it gives the substitute carers, as in special guardianship, clear control for the duration of a child's minority. So that's something that is kind of a particular interest to the Italian partners. The Hungarian context is very politically shaped by recent developments in and the results of the European elections and the kind of hardening of attitudes towards vulnerability and the kind of cultural the cultural glorification of power and force, in the words of our Hungarian partner. So they're looking for promotion of children's rights, of professionalisation of foster care training and support. They do have on paper a kind of a developing foster care system, but we're advised that it's of extremely low quality, and that there's an urgent need for standards to be raised, as I say in the next point. For diversion and restorative practice, and just a wide variety of placements for the kind of contingencies you need in foster care. Just a few quotes from the UK focus group with institutional actors to, before I close, just to give you kind of an idea of what the kind of key issues have been. This is the programme supervisor for the London region intensive fostering project. Ludicrously, he talked, there's only 5 placements. The High Court judge in our group said, how many placements are there? He said 5. That was an embarrassing moment in the group. But he said some of the turnaround impact of these placements has been fantastic in terms of you know, kind of radical changes in children's lives. He talked about an instance there of a child involved in a gang. He'd been shot when he was 10, and the issue about whether he could be helped to move away from his home environment, his home borough across London to get training, and eventually he's been kind of relocated, but after a process of intervention and support in a way that was really kind of extraordinary to hear about and not common. The magistrate's view is that specialist fostering is as common as snowflakes in the summer, that it's just a mockery to say that we have these alternatives for magistrates. They're so kind of difficult to access, so unpredictable in availability that it's a frustrating experience. The judge's view is that they want options. I feel quite strongly that we'd like to have an alternative, even if it's not just one model. In regards to the one model, it doesn't necessarily fit every offender, but you need a range. And we're talking about, obviously, cases that come to the Crown Court, heavy-end cases, where, again, we've got this kind of strong message in England that the range of alternatives needed by the judiciary doesn't exist. We also had a sort of informal message that the age of criminal responsibility at 10 is not favoured by the judiciary, that they would certainly look at 13 or 14 and something that met the European standard more comfortably. Finally, we had a safeguarding consultant who works with serious groups of group offenders, and said that the multiplicity of placement changes for many of the young people she's been working with have been breathtaking, and also the a disproportionate emphasis on early independent living that's against the grain in terms of their need for nurture and emotional support. Just moving on from that, we've come to a kind of agreement within the project that probably the kind of model that would fit our partners' needs as much as ours owes a lot to the secure-based model that Jill Schofield has been advocating in the UK and in Norway for some years now, and BAAF has published a string of rich publications about her work in foster care. So this secure-based model has been very well received, and also it's been perceived also as a kind of conceptual framework for quality standards that may be applicable across the different European jurisdictions, and this is obviously a kind of a serious focus now. And so the meeting we just had 2 weeks ago endorsed the use of that secure-based model, and it's also, we highlighted the legal professor from Salento, Claudius Messner, highlighted that we must keep up with European law, and there's been a case at the Strasbourg Human Rights Court, the Zhou case, Z-H-O-U. I don't know if anyone knows it. It's just the last 2 slides are on that. It's a Chinese woman who went to Italy, 2 children were sent back to her grandparents in China. She had a 3rd child in a relationship in Italy. The child came into care when the relationship foundered, and then there were issues about her contact being reduced and then cut off, and then the Italian authorities recommended and progressed an adoption. And she went to the Strasbourg court, and Claudius Messner said this is really a very important judgment in terms of European law. It's saying something more than just that children are social actors, but they're European citizens in a particular kind of way. Here, that he's talking about children and their parents enter a circle of vulnerable people to be protected. He said this is different from the Italian ideology about the minor and the all-powerful family. It is looking at the family as a kind of ecosystem that's entitled to the protection of human rights law. And he said it will take some time to be absorbed what the implications are, but it does shift the emphasis. And I suppose my concluding thought is that we're kind of reaching for, and I was very conscious of this in Germany 2 weeks ago. I was invited to the Children and Youth Conference that's every 3 years in Germany. It's a massive kind of awesome event. And I was talking on the same platform as a professor at Berlin who does lots of face-to-face work and direct project management of challenging adolescence. And I felt that what he was talking about in terms of the relationship-based focus, the inclusive attitude to the birth parents, and the kind of quality of openness was a kind of different starting point from some of the UK-based culture that I feel that hasn't travelled well in our project, and was a kind of better basis for realigning the project. That combined with the Strasbourg judgment, looking in a more kind of equitable way at the rights of all the parties, and then combined also with the focus group feedback, which I have no time to say now, but all the birth family groups in the 4 countries have strongly appealed to the professionals to have a continuing link with their children, to kind of combat stigmatisation and exclusion. That we're sort of reaching towards a more inclusive model that is kind of compatible with minimising risk and danger, but is more kind of accommodating of human rights law. So that's why I apologise in advance. We're not there yet in terms of the adumbration of what we're trying to get at, but we're kind of we're on a journey, and I hope we can get there, before the grant expires. But thanks very much.